Good afternoon, everybody. This is Mike Bartels. I'm the Chief Development Officer of Becker LLC. I'd like to first thank the Massachusetts Staffing Association for allowing us to speak today. We want to, in advance, just wish everybody a very Merry Christmas, Happy Holidays, and a Happy New Year, both healthy and happy. Just give you a quick background about our firm. Becker LLC is a mid-market law firm. We have a specialty niche in staffing. We have 7 attorneys who dedicate a large majority of their time to working within the staffing industry. Very, very proud members of Massachusetts Staffing and have been for over 3 years. And we look forward to giving you more content in the future. At this time, I'm going to turn the podium over to Chris Leddy and Sarah Davis, both from our firm and part of our staffing team. We're going to give you the presentation today. All yours, guys.
Mike, thank you for the introduction, and thank you, MSA, for having us. We plan to cover 2 topics today. The first is going to be privacy laws and then leave laws. Sarah's going to be starting us off with some of the important privacy laws you should be aware of as an employer in Massachusetts. I will then follow up with a high-level overview of some of the common leave laws in the state with a particular emphasis on Massachusetts paid family and medical leave. All right then, Sarah, let's jump into it. Massachusetts has laws governing the protection of personal information. Can you give us a high-level overview of some of those?
Sure, Chris. So since March 2010, a Massachusetts law referred to as the Standards for Protection of Personal Information has governed the protection of personal information of Massachusetts residents. So as an overview, this law was designed to establish minimum standards to be met in connection with the safeguarding of personal information. Now, this pertains to records in both paper and electronic form. So if you're filling out a paper document and sending it in, or if you're going online, which is very common now, and submitting personal information, it pertains to both. It also applies to all natural persons, as well as corporations, associations, LLC, all sorts of entities that own or license this personal information about Massachusetts state's residents, which can actually include businesses inside and outside of Massachusetts.
Sarah, so you can be a business incorporated and formed and operating outside of Massachusetts, but still be subject to this law?
Yes. So as I stated before, this law pertains to any businesses that obtains, owns, or licenses personal information of Massachusetts state's residents. So you don't need to be a person, a company, or a corporation actually organized or formed in Massachusetts. It's going to apply to you if you have that personal information. So getting into the grit of this law mandates that every person or business entity, as I stated before, that has information about Massachusetts residents is required to develop, implement, and maintain a comprehensive security program. And this security program is going to contain administrative safeguards, technical safeguards, and physical safeguards. And it applies to all information on Massachusetts state's residents. It doesn't matter if the business is actually in Massachusetts.
And Sarah, can you give us some examples of some of the safeguards that have to be in place?
Sure. So first I want to go back just to talk about what actually is personal information under this law. So the definition of personal information includes any of the following information in combination with a resident's first and last name or first initial and last name. So it's not going to be just one, it's got to be in combination. And when you look at that, it's going to be things like social security number and first and last name, driver's license, state issued ID cards, financial account numbers, credit card numbers, even without those security codes. And what's interesting, it has actually, under Massachusetts law, personal information is also recognized as biometric indicators. So that's going to be the DNA, the facial recognition that's very popular right now. So any of that combined with the first and the last name, or the first name and in the initials, that's going to be what's considered personal information law. Now, again, like I said before, under this law, all companies that obtain this personal information need to maintain a comprehensive information security program. Now, there are standards, but I want to say that when you're coming up with the standards for your security system, the law does take into account how big you are, how much information. So even though there is a standard, if you're a very small company, it's not the exact same as if, you're Amazon. So, but taking into account of that, there are a bunch of generalized standards that many companies use and proven very effective. So first, if you want to talk about admin safeguards, always designate one or more employees to maintain this program. You need to have these employees assessing continuously the reasonable and foreseeable risks to the personal information, and like I said, continuously evaluate it. And related to this evaluations of security measures is that in Massachusetts, companies doing business here under this law actually have a requirement that they need to provide training to employees as part of their overall information security program. And this includes, training on proper computer security systems, and it's an annual requirement that applies to both part-time and full-time employees. So that's important. A lot of companies will devise disciplinary actions for violations against the information security programs. Another good one is to right away remove terminated employees from access to its passwords. So if an employee has a password and while they're employed, they had access to the database of this personal information, as soon as they're terminated, you got to get rid of their personal identifiers to get into the software. Another big thing is, it's one thing if your company has like a very good security system, but if you're contracting with third parties, you need to make sure that they also are abiding by these regulations. So you can't say, oh, well, our security system is very good, contract with someone who has nothing, now they have access to the personal information. That's a problem. And that kind of goes into the technical safeguards. So another thing you can do, which proves effective, is, only allow employees that need this personal information to access it. If you have like a lower level employee that doesn't actually need access to this database of information, restrict their access. Obviously, another good thing, a big thing, is encryption. So if you have employees that have cell phones, that have laptops, that are, walking around with these devices, it's not uncommon for someone to leave a cell phone on a subway. So make sure that this information is encrypted so that if someone loses their cell phone, someone just picking it up can't, access it right away. So encryption's big. And also, with security systems, make sure that you have up-to-date firewall protection, operating systems, virus definite. You don't want like a virus and coming and getting into that information. That'd be a very, very big problem. As a breach, obviously, you have to notify. There is an obligation to notify the affected resident as soon as practical in the event of a breach of this information getting out.
Sarah, can you be more specific as to what constitutes an actual breach under the law?
Sure. So under the law, a breach of security of personal information is defined as the unauthorized acquisition or use of unauthorized use of encrypted or encrypted information that's capable of compromising the integrity of the information. So basically, in summary, it's if there's a breach, if there's a substantial risk of identity theft or fraud, and that's really, what everyone's very concerned about right now. And if there is any sort of breach that, risks this identity fraud, there must be notice provided to the AG's office and the Director of Consumer Affairs for possible further action.
And what's the penalty for noncompliance if they fail to do so?
Right. So failure to develop and maintain this type of program can be seen as a violation that's enforceable by the Massachusetts Attorney General. That could result in significant civil penalties. So thousands of dollars, $5,000 per violation, plus reasonable attorney fees.
All right, Sarah, in addition to the above, there were some new changes to data security laws effective in April 2019, which could have some costly impacts. Can you discuss some of those, please?
Yes. So there were amendments that do have costly impacts. So first, since the amendment, any company that has a data breach, as I just described with fraud, they need to offer victims of this breach free credit monitoring services. So this is going to be for most companies, credit monitoring services for at least 18 months after the breach. If you are a consumer reporting agency, this will span for a minimum of 42 months. So that's quite a while. The organization that experienced the breach also needs to file a report. that shows that, you know, this credit monitoring services, they're being complied with, they're doing it. And this is obviously to ensure that those affected by the breach are receiving the monitoring. Also, not only do you have to notify the AG now, but more things need to come with that. So you need to, someone reporting a breach needs to not only say the name of the business and the organization, but you need to define what kind of personal information was compromised by the security breach. If known, the person or entity who's actually responsible for the breach, and if the organization has a written information security policy and if they're updating it. So it's not enough just to have a policy in place to protect this information, you must be updating it. And that goes for, like I said before, you need to have training, you need to make sure everyone knows what's going on. And if you have a breach, and they're gonna know if you're not updating it, and it could be a problem. And again, I just want to stress that this all applies, even if the company is not formed or based in Massachusetts. If you are taking in any of that information about Massachusetts residents, then this applies to you and you can be on the hook. That's a lot of information. Security is a big subject.
Thanks, Sarah. Yeah,
Chris,
for sure.
we have a question.
Yeah.
Under the law, what time frame is considered practical?
I mean, like I said before,
regard?
Go ahead, Chris.
No, I was going to say, in what regard? Practical for what?
For the reporting?
Yes.
So I can check. I mean, as the statute, it depends on the size as well. Like I said, there are different levels. If you are a huge company, you're going to be held to a higher standard. But it's going to be as reasonable as possible. As soon as you find out that there's been a breach, you got to notify.
All right. It's also, here's further the question. It's for notifications to those impacted with 24 hours or 5 business days.
I'm sorry, can you repeat that?
All right. Under the law, what
Yeah,
time frame is considered practical for notifications to those impacted within
Right.
24 hours or 5 business days?
Well, I think it also depends on when you find out. Like if you find out and if there's a breach, you should report it 4 hours, you should. Because there's going to be an issue if there's any sort of delay, because while that delay happens, then there's going to be a violation for, like I said, identity fraud, all of that. So as soon as there's any indication of a breach, there should be reporting.
Thank you, Sarah.
Thanks, Sarah. Now we're going to jump into some background checks. As staffing companies regularly perform these and want to ensure they are compliant with the same. Can you give us some background on the state's requirements for these?
Sure. So with the privacy that we just talked about, which has been a big trend lately, you know, with the growth of all these companies, is background checks. And one of the biggest trends in the background check field is this movement called the ban the box movement. So the box refers to the question on job applications that ask applicants whether or not they've ever been convicted of a crime. So this ban law requires employers to remove this question, as well as other questions about criminal history from job applications in both the written application and further along. So obviously this legislation is meant to prevent employment discrimination against individuals with criminal records. The idea is that employers get a chance to form an initial impression on each applicant's current character before the stigma of a criminal conviction can come up. So as of today, 36 states, Washington, D.C., over 150 cities and counties have adopted this ban the box legislation. On the national level, the ban the box movement has been endorsed by directing federal agencies to delay inquiries into job applicants' records until later in the hiring process. In addition, at least 14 states, New Jersey, Vermont, go so far as to mandate the removal of conviction history questions from job applications for private employers, which is, a critical step towards ensuring people with records have a chance of employment. Now, since we're talking about Massachusetts today, Massachusetts enacted its modified ban the box law first in August 2010. And when it first came out, it prohibited employers from asking about any information related to a job applicant's criminal record in the initial written application. Get rid of that stigma. And then it also prohibited employers from requesting certain information from applicants at any point in the process, even after the application. So this included inquiries into arrests, violations of law, which no criminal conviction resulted. A first conviction of a misdemeanor. This could be drunkenness, simple assault, minor traffic violations. So those were prohibited. And also any misdemeanor where the date of the conviction or completion of incarceration occurred 5 or more years prior to the date of the application, unless there was more convictions for that same reason in that period. So that was all good. However, then in April 2019, they expanded this even further. So in April 2019, new reform passed, which amended what I just talked about and did more by further decreasing the time period. So the time period for asking about convictions went from 5 years to 3 years. So if it occurred 3 years prior, then you didn't have to disclose it. They couldn't ask about it. Employers are now additionally prohibited from asking applicants about criminal records that have been expunged. So that's a big deal because people come in, you get a big thing for something to be expunged, you get to an application, they ask, and there's confusion about what needs to be put down. Is it a record? Is it not a record? So now you can put no record exists. So applicants can put no record and just less confusion for all. They're also, employers now have to add language in this regard to the application saying and directing that, if you have an expungement or a criminal record, you can put no record. So there needs to be language on there as well.
Thanks, Sarah. Are there any exceptions to this rule that you just spoke about?
Sure. So of course there are exceptions. So, if you're applying for a position for any federal, state law or regulation that creates a mandatory presumption or, prohibits employing individuals with certain criminal convictions, think, financial institutions, daycares, there's just certain criminal convictions that they must know about and they're obligated to know about. So yes, exceptions.
And what about yeah, then.
Oh, sorry, let me just say one more thing. So yeah, so just like in summary, even exceptions, there needs to be some sort of nexus. So again, like that's what I want to stress. There are these they're restrained from certain things, and as long as there needs to be some nexus, like the daycares, etc. And also, what's interesting is that noteworthy because of these new limitations, it actually has had some resulting effects into things like negligent hiring claims. So in a negligent hiring claim now, an employer is presumed not to have notice of records that have been expunged, which makes sense because they don't know about them. So you can't bring things like up. So it comes full circle. It comes on both ends of the spectrum. So that's interesting.
Yeah, for sure. So Sarah, now that we discussed the background checks or getting people hired, let's talk about what's considered to be the next step of maintaining personnel records. Can you give the audience some guidance on this?
I can, even though they're probably sick of my voice by now. But yeah, so under the Massachusetts Personnel Record Law, the Massachusetts legislature has placed an affirmative obligation upon Massachusetts employers with 20 or more employees to abide by certain requirements of how to maintain personnel records.
And what are considered personnel records?
Sure, so the current law defines a personnel record in the very broadest terms. It includes any record kept by an employer that identifies an employee to the extent that the record's used or has been used or may be used or could be used relative to that employee's qualifications for employment, promotion, transfer, dispensation, or disciplinary actions. And inside of that personnel records, each personnel file must contain at a minimum names and addresses, date of birth, salary, wage, employment, and importantly, any sort of disciplinary actions, probation periods, and if applicable, obviously copies of termination notices. So, and related to that, as a result of 2010 amendments to the statute, an employer is under an ongoing affirmative action to notify an employee each and every time disciplinary action against that employee takes place in writing. So not only must an employer find an employee under these circumstances, but the notice to the employee within 10 days of any disciplinary note to that personnel file. So in fact, this 10-day notice requirement could be triggered, say, you know, two managers are talking about an employee upset, or, you know, just any sort of negative communication. Someone wanted to sit down, puts it in the file. That employee needs to be notified of that in the file at all times. They need to know what is going into that file. After notifying the employee, which you must do, the employee needs to get a chance to review the file as well within 5 business days. If there is any disagreement with information contained in a personnel record, then obviously there should be some sort of effort to try resolved. If they can't get it resolved, then employees do have a right to write a statement explaining which should be then becomes part of that file. So if it's ever transferred to a new employer, then that written statement explaining that there was a disagreement, why they disagree with it, is in that file, and it needs to stay in that file. So that's important. So also, if an employer of 20 employees elects to end personnel policy regarding terms and conditions, the policy needs to be, a physical copy needs to be in the office of the company so that everyone can inspect it.
Thanks, Sarah. And what are the consequences that employers face by not abiding by these laws?
Sure. So civil fine, not less than $500, and these rules are enforced by the Attorney General.
Awesome. Awesome. Thank you, Sarah.
And I just wanted to say too, while every employee is entitled to inspect the records, you can't just like inspect all the time. So there is a restriction 2 times annually to look at it. However, some sort of disciplinary action coming in that is not counted towards the two times. So you can look every single time that something is written about you, but other than that, 2 times.
Great. Thanks, Sarah.
Disagree.
That was definitely, that was a lot to cover in a short amount of time.
I'm losing my voice.
If anyone has any questions, if anyone has any questions with Sarah covered, please feel free to reach out to Sarah, Mike, or myself, and we'd be happy to discuss further. Now we're going to jump into the leave laws, and the first topic we're going to cover is the Massachusetts paid family and medical leave. Funding for this leave started a couple of years ago. However, it becomes effective or available to employees as of January 1st of this upcoming year. It applies to all Massachusetts employers regardless of size, and it is available to any employee while working for Massachusetts employers who has earned enough money over the preceding year to be eligible for unemployment benefits. This is unlike FMLA, which requires the employee to have worked for at least 1 year and a minimum of 1,250 hours. Covered individuals under the law include W-2 workers who work in Massachusetts, whether they are full-time, part-time, or seasonal, so it doesn't matter how often they work. Self-employed individuals, 1099 workers who work in Massachusetts also qualify, so long as they don't qualify as independent contractors and who make up more than 50% of their employer's workforce. In order for a 1099 contractor to be considered part of your Massachusetts workforce count, though, the 1099 contractor must have performed services as an individual entity, lived in Massachusetts, and performed services in Massachusetts.
Can I ask you a question, Chris? Under what circumstances are covered workers entitled to utilize the PFML?
Yeah, thanks. There's about 5 circumstances where leave is available. The first is to bond with a child during the first 12 months after the child's birth, or the first 12 months after the placement of a child for adoption or foster care, to care, to care for a family member with a serious health condition. A serious health condition is defined under the law for an employee's own serious health condition because of any qualifying event arising out of the fact that family member is on active duty or has been notified of an impending call or order to active duty in the armed forces, or in order to care for a family member who's a covered service member. Due to the nature of the foregoing leaves, the PFML is broken down into 2 types of leaves, right? You have the family leave and you have medical leave. Family leave is generally limited to 12 weeks in a benefit year. Medical leave is generally limited to 20 weeks in a benefit year. However, no individual is permitted to take more than 26 weeks in the aggregate of family and medical leave in the same benefit year. So although the aggregate is 32 weeks, it's capped at 26 weeks. Also, excuse me, a benefit year is measured going forward from 52 weeks from the Sunday immediately preceding the date that a covered individual first uses protected leave. Again, this is unlike FMLA, where you can choose, or that you, the employer, can choose the benefit year, such as a rolling period, calendar year, etc. Importantly, PFML, though, can run concurrent with FMLA to the extent it's taken for a qualified reason under FMLA. They're very similar, so this shouldn't be an issue. But you want to make sure that when you have your policy right now, that you do put this in your policy, that all leaves that can run concurrently with FMLA shall run concurrently. That way they're not being able to double dip into both. Also, there's a 7-day waiting period before the paid leave applies, but employees can use their PTO, their accrued PTO, during that time period. However, the one exception is for pregnant employees who take a medical leave during pregnancy or recovery from childbirth. If they have supporting documentation, and a family leave immediately follows thereafter, the 7-day waiting period for the family leave does not apply, which makes sense because they're already out.
So Chris, most family and medical leaves, both federal and state, provide employment protections for employees who exercise their leave rights. What type of employment protections are provided to covered workers?
Yeah, so there's a lot here, and employers definitely have to be cognizant of these. So the first is, a worker who has taken family or medical leave must be restored to the worker's previous position or to an equivalent position with the same status, pay, employment benefits, length of service credit, and seniority as of the date they took the leave. However, this is not a guarantee of employment, right? If a worker would have been fired, but for the leave, the worker can still be fired or demoted. Employers can still take those actions, and we'll get into what kind of proof is needed on that later. However, even while on the leave, they still retain preferential treatment for any other position that they had seniority in. So it works a lot like a union would work. A lot of Massachusetts operate like a CBA. Also, the taking of the leave will not affect the worker's right to accrue vacation time, sick leave, bonuses, advancement, seniority, length of service credit, or other employment benefits, plans, or programs. During the length of the leave, the employer must continue to contribute to the health insurance. So if you were contributing $500 while prior to leave, you have to continue to contribute $500 during the leave, although the employee is still responsible for his or her portion of it during the leave. Also, employers cannot force a worker to exhaust any rights to sick, vacation, or personal time while taking the PFML. This is a notable difference from FMLA, because FMLA explicitly allows employers to require employees to exhaust their paid time off. Obviously, FMLA is unpaid, where PFML is paid. Also, employers cannot retaliate by discharging, firing, suspending, disciplining, or through application of attendance policies otherwise, or interfere with any right to which the worker is entitled. And if they do, they're in violation of the PFML. They also can't take any adverse employment action for any employers file a complaint or instituted or cause to be instituted a proceeding under or related to PFML, or if they have testified or are going to testify about information connected to the PFL and the employer. And the next thing, it's extremely important to note, this is very hard for employers. So any adverse employment action which occurs at any time during the leave or during 6 months after the leave occurs, it's presumed to be retaliation. So, and that presumption can only be—
That's big, presumption. Yeah.
Yeah, so if the worker comes back slacking off, yeah, they come back, they're slacking off, they're not meeting performance goals. The presumption is that you retaliate against them, and you have to overcome this presumption according to law by clear and convincing evidence. This is an extremely high standard. It's the highest standard that civil courts have to overcome. So once they come back, even while they're out, make sure you're documenting everything they're doing. You have to have a paper trail. It cannot be a he said, she said. I mean, I guess it could be, but your witnesses better be on point, and the jury better hate the plaintiff in the case. There's also a 3-year statute of limitations, so that you can look back 3 years from the time that the action accrued. Damages include reinstatement, compensation for 3 times the lost wages. So if they've been fired for 3 years and they bring it on the 3rd year, that's three years of wages times 3. Benefits and other remuneration with interest, along with their legal fees and costs.
Now, what type of employer notice are required?
So yeah, the department put out or is requiring employers post in a conspicuous place on each premises that it owns or has workers at a notice that was prepared by the department, right? So it must be in English and each language other than English, which is the primary language of 5 or more workers at that workplace, if that language is available from the department. Also, employers must issue, so this is another onboarding thing, you must issue to each worker not more than 30 days from the date they begin their employment the following written information to each employee. An explanation of the availability of the family and medical leave benefits provided under the PFML, including rights to reinstatement and continuation of health insurance, the worker's contribution amount and obligations under the PFML, the worker's contribution amount, the employer's contribution amount and obligations of the PFML, the name and mailing address of the employer, the identification number assigned to the employer by the department, instructions on how to file a claim for family and medical leave benefits, the mailing address, email address, and telephone number of the department, and any other information that the department may deem necessary at the time. So you got to make sure you stay up to date on that. Delivery of this information is made when a worker provides a written acknowledgement of the receipt of the information. However, it also is deemed to be received if the worker refuses to sign the statement and you have the person who tried to get them to sign the document acknowledging that they refused to sign it. So if employers fail to comply with this, for the first violation, it's a civil penalty of $50, and for each subsequent violation, it's a civil penalty of $300. And employers have the burden of demonstrating compliance with it.
But what about the employees? What notice do they have to provide to employers? I'm assuming some.
So workers must give 30 days notice to the employer of the anticipated starting date. I mean, that's kind of flimsy though. It's really as soon as practicable. So if they know they're going out for surgery in 60 days, they should get the 30 days notice. Most of the time, people are just going to get sick or have a serious health condition they're not going to be aware of. You know, think of the current circumstances that we're in right now, COVID. They come down with it. You're definitely not going to get 30 days notice. So, however, no notice is required if an employer fails to provide the notice requirements that we just discussed. So that's why it's also critically important that you get that notice out to them so you have the right to notice. And then, so we'll jump into what information documentation is going to be required. The certification for medical leave is sufficient if it states that the date on which the serious health condition commenced, the probable duration of the health condition, and the appropriate medical facts within the knowledge of the healthcare provider as required by the department. The same goes for family care or family leave to care for a family member, except that workers must also provide a statement that the covered individual needed to take the care or needed to leave to care for the family member, along with an estimate of the time the worker is needed to provide that care. Certification for a worker taking family leave because of a birth of a child is sufficient if the worker provides either the child's birth certificate or documentation issued by the healthcare provider of the child or the person who gave birth, stating the child's birth date.
So can employers opt out of the PFML?
Yes, they can. Surprisingly, employers can opt out only if they provide benefits to their workers that are equal to or greater than the benefits provided by the PFML These are probably going to mostly be very large corporations because this is quite expensive. Such employers, however, have to apply for an exemption with the Department of Family and Medical Leave. If they don't get that exemption, they still have to provide the PFML.
And how is PFML paid for? You get into that.
So if you had 25 or more, if you had 25 or more covered individuals in your workforce last year, then you're responsible for making employer contributions for those covered individuals in your workforce. So there are two types of contributions. Again, family leave and medical leave. For family leave, it's up to 100% of the family leave contribution can be withheld from a covered individual's wages. So the employer doesn't have to make any, and that really equates to 0.13% of eligible wages. For the medical leave, up to 40% of the medical leave contribution can be withheld from a covered individual's wages, or in other words, 0.248% of eligible wages. Employers are only responsible for contributing the remaining 60% or 0.372%. If you had less than 25 covered individuals in your last year's workforce, you don't have to make any employer contributions this year. However, you still have to remit the workers' portion of the contribution on their behalf.
Thanks, Chris. You're probably losing your voice now too. So let's switch gears now to leaves for COVID-19. Most of our participants are familiar with the FFCRA now, but can you just give like a brief overview of it?
Yeah, so surprisingly, the bill that was passed last night, everybody expected it to be extended into this year because we're still in the middle of a crisis. Surprisingly, it does not do that. So as of January 1st, the FFCRA is no longer required. However, if employers do voluntarily provide these benefits or the benefits under the FFCRA, which is the emergency paid sick leave and the emergency paid family leave, through March 31st, 2021, they remain eligible to take tax credit for the leave. However, you do want to be aware some states have enacted their own versions of the FFCRA. So you want to be mindful of those depending on what states you're in. And then, I mean, obviously, workers are going to come down with COVID as we've seen a sharp increase in cases during the past couple months. A question that we get a lot is when employees return to work, does the ADA, Americans with Disabilities Act, allow employers to require a doctor's note certifying fitness for duty? According to the EEOC, yes. Such inquiries are permitted under the ADA either because they would not be disability related, or if the pandemic were truly severe, they would be justified under the ADA standards for disability related inquiries of employees. However, you just want to be careful because as a practical matter, doctors and other healthcare professionals are being inundated right now. So you might want to look at new approaches such as reliance on local clinics to write a form, stamp, or email certify that that the individual does not have the virus. And also under the ADA, all this information has to remain confidential. So make sure you keep the reporting obligations confidential, all the information provided confidential. Do not put them in their personnel files. Have a separate medical file for each person. And then a lot of questions from staffing companies we got is, may a temporary staffing agency or a contractor that places an employee in an employer's workplace notify the employer if it learns that an employee has COVID? Yes, surprisingly, according to the EEOC, you can. Typically, you're supposed to keep the name of the individual confidential. So if it was your internal workforce, you 100% have to keep it confidential. And you're just going to say somebody in our office came down with the virus. We're taking all precautions and do what you need to do under the CDC guidance. But however, because this is a little bit different, you're having your employees work at your client's work sites. The staffing agency or the contractor may notify the employer and disclose the name of the employee because the employer may need to determine if this employee had contact with anybody at their workplace. Just note, however, the ADA still does require the medical information to remain confidential. just whenever you think of something, try to disclose this. Err on the side of no, right? Don't disclose it. Call counsel, call whoever who's been guiding you through this, and make sure that you're disclosing the right information, because back to what Sarah talked about, the privacy laws, you violate those, you have your own separate issue. Even they may be trying to do it right, it will come back to bite you.
Now, do employers have to provide leave under the FFCRA if there's no work for the employee?
No, they do not. So the FFCRA, although it's only, I think we have 9 days left of it, it's they do not have to supply it at all. It's only if they're scheduled work and there is work for them. That was clarified in September in New York by the lawsuit brought by the state's AG. And Sarah, I think we're jump to the final types of leaves.
Okay.
So there's also just a few other, oh, not a few, there's a lot of leaves in Massachusetts. But we're going to cover, we'll cover some of them, the most common types. So the first one we'll talk about is jury duty. Employees are entitled to up to 3 days of paid leave without loss of wages, sick, or emergency, or personal leave, or any other benefit to serve on a central jury pool, state pittet, or grand jury. Thereafter, it can be unpaid. Also, there's the domestic violence leave. It applies for companies with 50+ employees, provides up to 15 days of domestic violence leave for a qualifying reason in any 12-month period. If the employee or family member is a victim of abusive behavior, generally unpaid, but that is at the discretion of the employer. You also have the paid earned sick time, which I'm sure everybody's familiar with by now. Depending on the number of employees, it could be paid or unpaid. Generally, employees will immediately upon hire begin to accrue sick time at a rate of 1 hour for every 30 hours of work, with a maximum of 40 hours. However, they're not required to be permitted to use the same until after 90 days of work. Use of this is capped at 40 hours per year, although 40 hours can roll over. So presumably you could have 80 hours in 1 year, but only be able to use 40 hours. It's not required to be paid out at termination or at the end of any year. There's also a leave called small necessities leave, and that's again for 50+ employees. If an employee who has been employed for at least 12 months and worked at least 1,250 hours, much like FMLA, they may be granted 24 hours of unpaid leave in any 12-month period for one or more of the following reasons: to participate in school activities directly related to educational advancement of a son or daughter, such as parent-teacher conferences, interviewing for a new school; to accompany a son or daughter to a routine medical or dental appointment, such as checkups or vaccines; to accompany an elderly relative of the employee to a medical or dental appointment, or interviewing nursing homes. The last one we'll talk about is voting, which it probably would have been better if we had this right before the election, but here we are. The law requires that employees who apply for a leave for voting be granted a leave of absence to vote during the 2 hours after the polls open in their districts. Payment for voting leave is at the discretion of the employer, so it can be unpaid or paid. Notably though, most employees have time to vote before or after work. So 1 or 2 hours in most cases is the maximum time needed to vote. Employees who request leave should explain their reasons for needing more time. May also be requested to prove that they voted by providing the name of the precinct where they cast their vote.
Hey, Chris, I have a question from one of our one of our attendees. If a client's place of business closes for 2 weeks because of a case of COVID, do temps at that location, are they eligible for the 10 days of COVID pay?
There's no work for them. Unless you have other work for them, no. So I mean, I would say no, because you have to have work for them in order for them to I mean, it's the whole purpose of it is to keep people getting paid for work they would otherwise perform. And here they wouldn't otherwise be performing it.
Okay, thanks.
And yeah, that's basically our presentation for today. So if anybody has any other questions,
Yeah,
we'll
Chris, I
open up
do
to
have
you guys.
I have another question. Again, one of our attendees asked, their bank had a breach where names, addresses, and account numbers were exposed. They have not offered any type of credit monitoring for that. Is that something that should be offered?
I would look into that quick.
Is that something we should, what we could do is get that answer out to the
Of
group.
course. Yeah, if you want to send me an email and just give me a little bit more specifications, we can definitely talk about that.
Not a problem.
Yeah, I think definitely it has to be, even outside of Massachusetts. I'm sure there's federal banking laws that you have to. So I think it's more than just even Massachusetts law.
Yeah, that's what I think of
about.
when you said the bank. Like, I'm sure there's an issue.
All right. Well, just so everyone who attended is known, we have recorded this session. We're going to be sending a copy of this to Christine Mangan. She will distribute it to everybody. If you have any questions for any of us, Christine has our email. We'll be happy to answer any of the questions that we can for you as we go along. And I want to thank both Sarah and Chris for your time today. And we look forward to doing more of these in 2021. Thank you, everybody.
Thank you so much.
Thanks, everyone.